Civil Rights shall come to order. Today is Wednesday, June 23rd at 4 p.m. I'm Brianne Hamill, the chair of the New York Advisory Committee. Also present on the meeting are other committee members. That includes Athena Mutwa, Jamil Dakwa, Donald Durham, Tiffany Graham, Robert Klump, Raphael Mangwal, and Craig Trainer. I want to just start by thanking all of the speakers, all of the panelists, all of the committee members who were able to reschedule. So the meeting from Friday was able to be rescheduled today. Juneteenth was made a federal holiday. It was celebrated on Friday. So we're continuing the briefing for today with as many panelists and committee members we could. So thank you so much. Also present is the commission staff, and there may be members of the public who have joined in a listen-only capacity until invited to speak during public comment at 5:45. The U.S. Commission on Civil Rights is an independent bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws because of race, color, religion, sex, age, disability, national origin, or in the administration of justice. In each of the 50 states in the District of Columbia, an advisory committee to the commission has been established, and they are made up of responsible persons who serve without compensation to advise the commission on relevant information concerning their respective states. Today, our purpose is to hear testimony regarding racial discrimination and eviction policies and enforcement in New York. If speakers begin to veer away from the civil rights question at hand to discuss possibly important but unrelated topics, I will interrupt and ask them to refrain from doing so. Based on information collected through testimony, our committee will draft a report that will include findings and recommendations that will be shared with the U.S. Commission on Civil Rights. The commission will then forward those recommendations to the appropriate federal and state entities. At the onset, I want to remind everyone that this meeting is being recorded and will be transcribed for the public record. I also wish to remind everyone that today's meeting is part of a series of meetings the committee is hosting on this topic, and all the meeting information is available in the Federal Registry. I'd also like to present the ground rules for today's meeting. This is a public meeting. It's open to the media and the general public. The meeting is being recorded, as I've said. We have a full schedule of people, our panelists, who will be making presentations within the limited time available. The time allotted for each presentation must be strictly adhered to, and this is going to include presentation by each of the 5 panelists for 10 minutes. After all the panelists have concluded the statements, the committee members will engage them in questions and answers. To accommodate persons who are not on the agenda today but wish to make statements, we've scheduled the public comment session today from 5:45 to 6 p.m. At the appropriate time, when indicated to do so, anyone wishing to make a statement should press *3 on their phone or use the raise hand function on their web browser to request that their line be unmuted. In addition, written statements may be submitted by email to the U.S. Commission on Civil Rights to mtrachtenberg@usccr.gov until July 25th. Though some of the statements made today may be controversial, we do want to ensure that all invited guests do not defame or degrade any person or organization. As the chair, I reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand. In order to ensure that all aspects of the issues are represented, knowledgeable persons with a wide variety of experience and viewpoints have been invited to share information with us. Any person or organization that feels defamed or degraded by statements made in these proceedings may provide a public response during the open comment period. And their organizations could file written statements for inclusions in the proceedings. I urge all persons making presentations to be judicious in their statements today. The advisory committee appreciates the willingness of all the participants to share their views and their experiences with the committee. And finally, the rules for the committee Q&A portion of the panel discussions. The Q&A session is reserved for committee members only. The committee may ask members of the entire panel or individual members of the panel after all the panelists have had the opportunity to prepare and give their prepared statements. Committee members must be recognized by the chair before asking any question of the participants. And in addition, because of the large number of members we have in a short period of time, each committee member may only ask one question. If time permits, I'll circle around to give you an opportunity to ask another. So at this time, I again thank all the panelists and the committee members who could be present here today for attending the briefing. And I'd like to invite our first panelist, Sandra Park, to present to us. Thank you. I'd ask everybody to mute themselves while Sandra is speaking. Ms. Park?
Yes, thank you so much for the invitation to testify today. My name is Sandra Park. I'm a senior attorney with the Office of the National ACLU Women's Rights Project, and I lead the ACLU's work to challenge discrimination experienced by survivors of gender-based violence and to advance equal housing rights for women of color, particularly Black women. Today, I will be discussing evictions as a racial and gender justice issue, 4 different ways that evictions and eviction-related policies and processes can harm and undermine the civil rights of women of color, and recommendations for the federal and state governments. I plan to submit a detailed written statement as well. First slide, please. As the Commission has heard, second slide. As the Commission has heard from researchers and scholars, the U.S. evictions crisis is a racial and gender issue with vast civil rights implications. The factors leading to the current eviction crisis are part of a longer history of systemic bias and housing discrimination in this country. The result is that individuals who live at the intersection of race and gender discrimination, namely women of color, particularly those with children, are at the highest risk of eviction. Next slide. As our data analytics department concluded, using data shared from the eviction lab, Black women renters had evictions filed against them at double the rate of white renters or higher in 17 of 36 states where we had data, including in New York. Evictions overwhelmingly burden communities of color and women, and Black women in particular, who are overrepresented in low-wage jobs and who shoulder the majority of caregiving responsibilities. Other research has shown that having children is the single greatest predictor of whether someone will face eviction. All of these factors put low-income, single mothers who are women of color at particular risk of eviction. It means that they and their families are subjected to the myriad short-term and long-term financial, health, safety, and social consequences of losing one's home. I now turn to one way evictions undermine people of color civil rights, eviction record screenings. Next slide, please. Back one. Eviction records unfairly restrict tenants' housing for years, locking out people of color and particularly Black women from housing that offers greater opportunity. Across the country, landlords routinely use screening policies that deny housing whenever an applicant was named in an eviction case, even when a court never ordered the eviction. Black women are the group most likely to be harmed by these types of eviction screenings. Not only do Black women renters disproportionately face eviction at higher rates, they are also more likely to have a case filed against them that is later dismissed. Thus, it is especially unfair that these tenants are marked with the scarlet E, with eviction records that stigmatize them for years as they submit housing application after application and face denials. Such practices are particularly difficult for survivors of domestic violence, who often face eviction because police have responded to their homes even when they themselves are a victim of the crime. As eviction moratoria end, we expect to see a devastating rise in eviction filings and judgments, creating records that tenants will bear for years to come. Ending unfair eviction screenings would open the door to opportunity for families to many communities that are currently closed to them. Another type of common law and policy that I want to highlight that too often results in unjust and discriminatory evictions are crime-free and nuisance ordinances, as well as crime-free housing programs. Local laws called crime-free or nuisance ordinances and crime-free housing programs mandate or encourage the eviction of tenants who seek emergency assistance or who live in properties where criminal activity allegedly occurred. Next slide. These ordinances exist around the country, including in New York. They run parallel to the criminal legal system, counting alleged criminal violations as triggering separate punishments under the ordinance, although they typically do not require any type of arrest or conviction. They also usually provide no notice or process for tenants to contest alleged violations. Research has shown that these ordinances disproportionately threaten the housing of people of color, survivors of domestic violence, as well as people with mental disabilities. Our research showed that in many cities, nuisance ordinance enforcement falls hardest on people of color. We have reports with NIGLU, the New York Civil Liberties Union, in 2018 that documented this in Rochester and Troy, New York. And our research also from 2016 shows that survivors of domestic violence are most punished under these ordinances, including facing eviction as a result of violations of the nuisance ordinance. These laws and policies drive evictions in many communities, but operate with little oversight or accountability for how they violate civil rights. Third, I want to mention the threat of eviction is often used as a tool to commit sexual harassment targeting Black women. Next slide. Sexual harassment of low-income women of color by their landlords is a significant and widespread national problem. It is perpetrated primarily by male landlords and housing providers against women who are poor, often young, and disproportionately women of color. And this has all been documented by Professor Oliveri of the University of Missouri School of Law, as well as others. Landlords and housing managers use the threat of eviction to commit sexual harassment against their tenants. Women may submit to unwanted sexual activity with landlords out of fear of being evicted, or if they refuse to participate in sexual activity, landlords retaliate by filing evictions. Our current fair housing law, with some exceptions, generally recognizes that sexual harassment in fair housing violates tenants' civil rights. But the law falls short in addressing how eviction can be used as a tool to sexually harass. If a woman cannot pay or is behind in rent, she is unlikely to report sexual harassment, as that might provoke an eviction action. Instead, she may endure the harassment and/or face eviction when she challenges it. And again, what the research has shown and cases have shown is that this disproportionately um, is experienced by women of color. Fourth, structural inequality fuels the unfairness of eviction proceedings. As you've heard from other scholars, there are myriad ways that structural inequality and racism contribute to the evictions crisis, including in terms of who owns property and who rents. I want to briefly highlight that eviction proceedings historically have been unfair and imbalanced, with the odds stacked against tenants. One obvious way is who is represented and who is not. The National Coalition for Civil Rights Council compiled statistics from 24 jurisdictions in the United States and found that on average, 3% of tenants have legal representation in eviction cases compared to 81% of landlords. In New York City, before the Right to Counsel passed, this imbalance was also shown, with 1% of tenants with representation compared to 85% of landlords. Thus, in many cities, the majority of eviction cases involve pro se women of color tenants who lack access to counsel, trying to navigate legal proceedings against lawyers for the landlord. They therefore are rarely able to assert any relevant legal defenses or counterclaims that may be available to them, or even mitigate the legal judgments that may be entered against them. I want to turn briefly to recommendations. We'll submit several of these in our submission, but our recommendations for the federal government include: one, that the federal government should halt evictions until the public health emergency has ended and it can ensure that rental assistance funds are fairly distributed. Two, that the federal government should encourage states to use federal relief funds to establish the right to counsel in tenant landlord proceedings. There's several states and cities that have used federal relief funds for that purpose, and the federal government can play a more active role in encouraging these initiatives, including in New York State. Third, we urge the federal government to enact the Violence Against Women Reauthorization Act of 2021, which includes a section that protects landlords and tenants from penalty based on their request for assistance or based on criminal activity of which they are a victim or otherwise not at fault. And that includes protecting them from penalties such as eviction. The bill has passed the House and needs action in the Senate and would very much help address the issue of crime-free and nuisance ordinances and their effect on tenants in encouraging evictions. Fourth, HUD should adopt regulations interpreting the affirmatively furthering fair housing obligation and disparate impact liability under the Fair Housing Act that can be used to challenge discriminatory eviction-related policies and practices. Fifth, in addition to new regulations on affirmatively furthering and disparate impact, HUD can also take action to directly address eviction record screening policies. HUD should adopt a regulation or guidance stating that blanket screening policies for tenants with eviction history violate and raise other civil rights concerns under the Fair Housing Act. 6, HUD should also take action focused on preventing sexual harassment, including the use of eviction as a tool to commit sexual harassment. HUD has taken commendable enforcement actions, but there's a lot more that can be done on the prevention side, including requiring housing providers that receive federal funds to adopt policies around sexual harassment in housing and providing trainings for housing providers on these issues. In terms of recommendations for New York State, we also urge New York to ensure the speedy and equitable distribution of rental assistance and to ensure that the expiration of any state moratorium currently set for the end of August is tied to the effective distribution of funds. Second, that New York should adopt and fund the right to counsel for tenants in eviction proceedings throughout the state. Third, that the New York Attorney General should investigate and enforce a 2019 state law protecting tenants from nuisance ordinances, a law that has been enacted a couple years ago, but that many municipalities retain these ordinances and the AG's office has not taken enforcement action. Fourth, that New York should take action to fully implement the state prohibition on using eviction records to screen prospective tenants and to strengthen the law. And I think my time is up, so I will stop there and look forward to any questions from all of you. Thank you.
Thank you so much. Thank you so much, Ms. Park. All right, next I call on Deborah Thorpe. It's time for you to present. Thank you so much for being here with us today. Ms. Thorpe.
Great. Thanks so much. Good afternoon, everybody. My name is Deborah Thrope, and I'm the Deputy Director of the National Housing Law Project, or NHLP. Thank you so much for having me here today to discuss discrimination and eviction policies. NHLP's mission is to advance housing justice for poor people and communities. We achieve this by strengthening and enforcing the rights of tenants, increasing housing opportunities for underserved communities, and preserving and expanding the nation's supply of safe and affordable homes. NHLP also hosts a field network of about 1,800 legal services attorneys and other housing advocates working directly in the field representing tenants. And it's this network, the Housing Justice Network, that informs a lot of our policy advocacy. Today, I'm going to discuss the current eviction crisis and how it falls disproportionately on people of color, and then offer several policy recommendations to help us work towards race equity. Thanks so much. Next slide, please. Actually, you can go to the next slide. Thank you. So I'm going to start before the pandemic, when the U.S. was already facing an affordable housing crisis. 1 in 4 renters were severely cost burdened, meaning they spent more than half of their income on housing. A disproportionate number of these renters were Black and Latinx families who experienced high rates of housing instability. These families were one paycheck away from being forced to choose between food, medical care, and rent. Enter COVID-19. Next slide, please. The pre-pandemic affordable housing crisis set us up perfectly for the eviction crisis that we face today. According to June's U.S. Census Bureau's Household Pulse Survey, there are 7 million households in the U.S. delinquent in rent, with 3 million households likely to leave their homes due to eviction within the next 2 months. So while we've so far managed to avoid the tsunami that was predicted in March 2020 by enacting tenant protections such as eviction moratoria, federal rental assistance, and other measures, it is likely a matter of time before we see COVID's full effect on communities. And if anything, the pandemic has highlighted the importance of eviction prevention as a key factor in public health. In the case of COVID, for example, eviction prevention and housing stability was in fact disease prevention. Next slide, please. But evictions have other profound effects as well. Evictions cause disruption of employment and education because families often have to attend court appearances and eventually could be forced to move. They cause a loss of personal belongings because oftentimes landlords and the sheriff sometimes will throw property out on the street, and the inability to access other housing because, of course, the eviction can end up on your credit report. And then evictions also have an impact on communities. When people are displaced, we see a loss of workers, loss of productivity, There are huge impacts on schools and childcare providers when families are forced, to pull their kids out really quickly. And overall, we know evictions can really uproot families and communities across the country. Next slide, please. And there are, of course, enormous racial and gender disparities among eviction rates, as you heard from other presenters. Black and Latinx households are a disproportionate share of defendants in eviction cases and receive the lion's share of judgments. Black women with children in particular are most impacted. Next slide, please. To address the root causes of the racial disparities, a range of policies are needed at all levels of government. So I'm going to discuss 5 recommendations today that will pave the road for housing stability and race equity. Next slide, please. First, to tackle issues around evictions, government must address the systemic racial and economic inequities tied to the civil court system. Access to meaningful representation for low-income families is critical. Nationwide, 3% of tenants are represented by an attorney in eviction cases compared to 81% of landlords. And evictions are too important to allow tenants to go unrepresented. Tenants that do not have a lawyer during the eviction process forfeit important rights, lose a home they could have retained, and forego substantial financial benefits. There's now significant data in this field showing the impacts of a right to counsel in eviction cases. New York City's Right to Counsel program, for example, has seen incredible success with 84% of tenants who had a lawyer remaining in their home. In most areas in the state of New York, but for some in New York City, not only do most tenants go unrepresented, but landlords are not required to provide any reason for an eviction. Just cause laws prevent people from being unfairly evicted by limiting the grounds that a landlord can evict to non-payment of rent or other lease noncompliance. These 2 strategies, the right to counsel plus just cause eviction protection, go hand in hand to address the court system's inequities because they provide tenants with exercisable legal rights and unlawful detainer defenses, such as uninhabitable living conditions, or the right to request an accommodation based on an individual's disability. Next slide, please. Next, the government must capture data on illegal evictions and enforce policies that make landlord harassment and self-help evictions illegal. Although anecdotally, we know that many illegal evictions are racially motivated, there's little to no data that tracks informal or illegal evictions that occur outside the jurisdiction of the courts. So my organization did a survey of our members last June. It was early on in the pandemic, and the CARES Act federal eviction moratorium was in place for many tenants. And we asked our network of legal services attorneys about the problems they were seeing on the ground. And 91% of respondents reported illegal evictions in their service area, including lockouts and landlord harassment. And this was with a federal eviction moratoria in place, although granted there's no deterrent in the CARES Act for illegal evictions. So any comprehensive eviction strategy, prevention strategies must address these illegal evictions, again, that are occurring outside the jurisdictions of the court. Next slide, please. Next, state courts must work with local governments to create eviction diversion programs throughout the state, especially because failure to pay rent is by far the most common reason for an eviction. Coupling a pre-filing eviction diversion program with access to emergency rental assistance can be a key way to resolve landlord-tenant disputes and promote housing stability. There are a number of successful models across the country, but generally in an eviction diversion program, courts collaborate with local government, community groups, and others to intervene with an eviction before it is filed with the court and provide the necessary supports to tenants, including no-cost legal assistance and rent relief. So I've provided on the slide suggestions for components for an eviction diversion program, and this is a product of our work with our local legal services attorneys in our network. Philadelphia's model, which was implemented during the pandemic, is one in particular to watch. Next slide, please. Government can also play an important role in strengthening restrictions on tenant screening. So there are long-term consequences for families who get evicted. Tenant screening companies access eviction records, which then end up on an individual's credit report, no matter what the disposition of the case. Housing providers are then free to deny family housing for past rental history. Nationally, Black and Latinx families who experience higher rates of eviction are permanently barred from accessing huge segments of the rental housing stock due to the eviction on their record. And this includes even federally assisted affordable housing programs like HUD Section 8 program, public housing, and the low-income housing tax credit program. So tenants end up in high poverty neighborhoods with landlords who are willing to accept their application despite having an eviction on their record. And this furthers racial segregation, which is why you often hear tenant screening problems referred to as the new or modern redlining. Screening people for evictions reinforces systemic racism and raises a number of fair housing and civil rights concerns. Next slide, please. So here's a great quote from the founder of a major tenant screening company. It is the policy of 99% of our customers in New York to flat out reject anybody with a landlord-tenant record, no matter what the reason is and no matter what the outcome is, because if their dispute has escalated to going to court, an owner will view them as a pain. And this is from 2006, but a more recent statistic from another tenant screening company from 2017 is that nationally, 85% of landlords say they screen for evictions, while 90% screen for credit and criminal history. So this is why, effective in 2019, New York State has a law that makes it illegal to screen for past evictions, which is a great first step, but enforcement here is going to be key. And further, all levels of government must also ban the use of credit and criminal history in tenant admissions decisions, because these factors too can be a proxy for race and are discriminatory under fair housing laws. Next slide, please. My last recommendation is to fund long-term housing support for families. We know that some families that are at risk of eviction simply can't afford rental housing on their own anymore. As we've seen throughout the presentation, and others have talked about the fact that Black and Latinx renters are disproportionately severely cost burdened, but also high rates of homelessness. And expanding rental assistance will provide long-term housing stability to these families. Housing vouchers in particular can help address the history of segregation. And there's a lot of data that shows the incredible impact of vouchers on low-income families and children in particular. Vouchers allow families to move to low-poverty neighborhoods with high-performing schools, reliable public transportation, and quality jobs. And where we live has a lasting impact on our health and future economic advancement. Children who move to high opportunity areas, for example, tend to have greater adult earnings and educational attainment. And research also shows that neighborhood poverty is correlated with behavioral and emotional health. Next slide, please. So indeed, federal, state, and local government should fund housing vouchers to address racial disparities among evictions and the impact of evictions on families and communities. Next slide, please. Thank you very much. I look forward to questions.
Thank you so much. So I'll call on Commissioner Johnathan Smith, please.
Good afternoon. I'm Johnathan Smith. I'm the Interim Commissioner of the New York State Division of Human Rights. I want to thank the New York Advisory Committee of the U.S. Commission on Civil Rights for inviting the division to participate in this important discussion regarding the role of racial discrimination in housing eviction practices. The mission of the Division of Human Rights is to ensure that every individual has an equal opportunity to participate fully in the economic, cultural, and intellectual life of New York State. To that end, the division enforces the oldest state anti-discrimination law in the country, the New York State Human Rights Law. First enacted in 1945, the New York State Human Rights Law remains one of the strongest and most robust laws of its kind in the country. The law covers employers, housing, places of public accommodations, non-sectarian educational institutions, credit, and even certain issues in relation to insurance and licensing. The law prohibits discrimination based on race and color, age, creed, disability, gender identity, national origin, sex, sexual orientation, and in addition other traits without explicit federal parallels, such as familial status, lawful source of income, marital status, military status, pregnancy-related conditions, favorably resolved arrest records, and certain sealed criminal convictions. The primary way the division enforces the law is through the investigation and adjudication of complaints of discrimination. And approximately each year, the division receives around 6,000 complaints from New Yorkers. At the division, we also have the power to initiate investigations of widespread patterns of systematic discrimination. Yeah, as I mentioned, housing discrimination is a vital component of the protections under the New York State human rights law. Those protections were added in the 1950s, over a decade before the enactment of the Federal Fair Housing Act of 1968. Almost all forms of housing, including 3 or 4 family homes, have long been covered by the state human rights law. Our law has also continued to grow and expand over time. And for example, in 2019, the law was amended to include lawful source of income, so protections for individuals who have governmental vouchers, such as Section 8, are also included as a protected category under the state human rights law. We also work very closely and have a work share agreement with the U.S. Department of Housing and Urban Development, or HUD, to ensure that New Yorkers' rights are protected under both state and federal law. New Yorkers who believe that they have faced discrimination may file a complaint with the division, and those complaints can also typically are dual filed with HUD if applicable federal protections exist as well. We have a specialized housing investigations unit, which handles all of our housing complaints statewide. That unit is responsible for investigating complaints to determine if there is probable cause to believe that the law has been violated. If probable cause is found, the division will prosecute the complaint and either adjudicate it to a public hearing presided over by a division administrative law judge or pursue the matter in New York State Supreme Court. As with all complaints received by the division, the majority of our housing complaints are resolved through settlement. Since 2016, the division has received approximately 2,600 complaints of housing discrimination from across New York State. Given the population's distribution, over half of those complaints originated downstate, the New York City region. A little over 4% came from Erie County, Buffalo area, and a little over 2% originated in Albany County. Most of the housing complaints that we receive in the division involve issues related to reasonable accommodation for individuals with disabilities, as well as refusals to rent or sell housing due to a protected class. What we surmise is that given that landlords in New York State are required to file an action in state court for eviction proceedings, many tenants who face eviction may likely choose to keep their dispute in a single forum as opposed to also file a complaint with the division and then have to deal with complaints or matters in 2 forums at the same time. Next slide, please. That being said, evictions or threats of evictions have made up approximately 28%, or 740 complaints of the housing complaints that we have received since 2016. 340 of these eviction-related complaints, housing complaints, have involved allegations of racial discrimination. Next slide, please. Slightly over half of these complaints, about 180, originated from New York City. 18 were from Erie County, and about 7 were filed in the Albany area. Many of the complaints that we have received that I just referenced are still going through the division's investigatory and or adjudicatory processes. And so as a result, I can't speak about any of the details of those matters. However, 43 of those matters have resulted in either final orders in favor of the complainant or settlements before finding any finding of fault. These orders and settlements often allow the complainant to stay in their homes and often include training provisions and often monetary benefits as well. Among these 43 complaints, there has also been around $120,000 of damages or monetary awards to complainants. I did want to provide just a a few quick examples of the types of allegations that we have seen in the division that kind of intersect at the intersection of eviction proceedings and allegations of discrimination. So for example, in 2020, we received a complaint from a Black woman in Brooklyn whose lease expired and who was served with an eviction notice just before the pandemic shut down the court system. In her complaint, she alleged racial bias, alleging that the landlord treated her differently than her white tenant counterparts. For example, she highlighted how the landlord had moved to evict her, even though she had actually been current in her rental payment, whereas there was one of her white neighbors who had been withholding his rent for several months, and yet there had been no attempt to evict that individual. After she filed the complaint with the division alleging racial bias, the landlord negotiated a settlement with the tenant, allowing her to stay in the unit. In another matter, a Black woman who lived for over 26 years in a predominantly white housing complex outside of Albany was given a 3-day notice to vacate for non-payment just 2 months after a new property management company took over the complex. She informed the management company that she in fact had paid her rent, was not behind, didn't owe any back rent, and they rescinded the eviction, the notice to vacate. However, just a few weeks later, they terminated her lease and told her to vacate, at this time citing a history of police reports and complaints against her. And once again, the tenant denied those accusations. I would also note, too, that under the New York State human rights law, housing providers are prohibited from discriminating against an individual for a favorably resolved arrest record as a separate basis of protection. But within a few weeks of the tenant filing with the division, the management company came back with a settlement in that matter as well. I will close by just noting that the enforcement of fair housing laws remains a key priority for New York State. In response to the pandemic, Governor Andrew Cuomo and the New York State Legislature have enacted a number of new housing protections, including extending an eviction moratorium for individuals and households facing economic hardship. Additionally, the governor has announced approximately $2.7 billion would be made available to those households in need of rental relief. And critically, those rental relief funds are protected lawful sources of income under New York State human rights law, and so therefore they cannot be lawfully refused by landlords in New York State. And the division stands ready to pursue such claims and to protect the rights of New Yorkers facing economic hardship or unfair eviction. Thank you for the opportunity to testify today, and I look forward to any questions you may have.
Thank you so much, Commissioner. All right, at this time, I'll call on Commissioner Carmelyn Malalis, Commissioner of the New York City Commission on Human Rights.
Thank you for that. Good afternoon, members of the New York Advisory Committee to the U.S. Commission on Civil Rights. Thank you for this opportunity to speak with you today about housing discrimination in New York City and its impact on and relationship to the eviction crisis in New York. My name is Carmelyn P. Malalis, and I am the chairperson and commissioner of the New York City Commission on Human Rights. This past year and a half has been a historically difficult time as a result of the pandemic and the strains it has placed on people's family, work, and personal lives. The pandemic has laid bare many long-standing problems in our communities, including race and gender-based inequities and the lack of economic and housing security that are at the heart of today's inquiry. The history of displacement, particularly of Black, Indigenous, and other people of color, has long roots in New York City, tracing back to the original dispossession of the Lenape people from their homeland, an experience shared by many other Indigenous peoples across this country. New York City's history is stained by examples of intentional exclusion and displacement of communities of color through a variety of practices. After the Great Depression, the federal government redlined parts of New York City, identifying regions that were deemed ineligible for guaranteed home loans because the residents were Black or were otherwise regarded as detrimental influences. The exclusionary whites-only housing policy of Stuyvesant Town, a subsidized housing complex, was upheld by the state's highest court in 1949. And under the banner of development, urban planners bulldozed poor Black and brown communities in the 1930s through 1960s to make way for city parks, highways, Lincoln Center, and other projects. These are just a few examples, but I note them today because their vestiges remain with us. And I encourage the committee to acknowledge these historical underpinnings in their report. First, allow me to provide some background about the Commission's work. The New York City Commission on Human Rights is responsible for enforcing the New York City human rights law. It's one of the broadest and most protective anti-discrimination and anti-harassment laws in the country, with 27 protected categories that reach nearly all aspects of city living, including but not limited to housing, employment, and public accommodations. The large number of protected categories is in part attributable to the fact that the Commission and New York City legislators have recognized the need to address situations in which certain forms of discrimination may function as proxies for more recognized types of discrimination or have disproportionate impact on marginalized communities. For instance, disability, immigration status, and lawful source of income discrimination are three areas of protection under our law in which people of color, particularly Black and Latinx people, tend to be overrepresented. The Commission accomplishes its mandate by affirmatively providing public education regarding our law and human rights issues, engaging in affirmative outreach, addressing intergroup tensions in the city, and releasing public information and art campaigns to provide visibility to the city's diverse communities and human rights issues, and as well through civil legal enforcement of the city human rights law. The Commission's Community Relations Bureau is responsible for the city's community outreach and public education and responds to bias incidents throughout the city. CRB utilizes the over 30 languages spoken by Commission staff to provide free workshops educating individuals on their rights, as well as businesses, employers, and housing providers on their obligations under our law. It also develops a range of community-centered programming, creating visibility for the city's diverse communities and addressing issues relevant to the Commission's mandate. Examples of housing-related programming include restorative justice circles, fair housing symposia, town halls on gentrification and displacement, tenant and homeowner research fairs in different languages, and mobile clinics addressing lawful source of income discrimination. The Commission's law enforcement function is performed by our Law Enforcement Bureau, which investigates and prosecutes alleged violations of our law. Members of the public may file an administrative complaint at our agency. The Bureau also affirmatively initiates its own investigations into specific incidents or potential patterns of discrimination upon receipt of tips from the public, media, or other sources, or in situations where the Bureau's testing unit has confirmed discriminatory activity. In 2016, the Commission revamped its testing program to augment the Bureau's affirmative investigations, especially in the area of housing. Bureau testers identifying as members of a protected class perform tests to ensure that they are not treated differently by landlords or real estate brokers solely because of their protected class. The Bureau may issue a cease and desist letter to a landlord or broker, directing them to take specific actions within a date certain to comply with our law. The Bureau may also file a complaint, investigate further, and litigate the matter. In the last 5 years, the Bureau conducted 1,298 different housing-related tests in New York City. In some cases, as an alternative to filing a formal complaint, the Bureau may pursue pre-complaint intervention to quickly resolve a dispute without the need for investigation or litigation. The Commission has been particularly successful in preventing evictions through this process, often in cases in which a tenant is seeking to utilize a rental voucher for their current apartment, or where the tenant withheld rent due to a landlord's failure to provide a reasonable accommodation for a disability. In the last 4 years, the Bureau successfully intervened in 39 cases in which some form of race, color, or national origin-based housing discrimination was alleged. Lawful source of income discrimination is the leading basis for housing-related pre-complaint interventions, making up 50% of all such interventions at the Commission. In fiscal year 2020 alone, the Bureau successfully intervened in 177 cases in which people were denied continued or prospective housing opportunities because they were seeking to pay for housing with some form of government assistance. The Bureau has pursued cases alleging disparate racial impacts where housing providers have adopted policies that exclude or otherwise disadvantage housing voucher recipients and people with disabilities, among other protected categories. In 2019, recognizing the need to provide immediate housing security to a growing homeless population, the Commission began securing broad-reaching relief in the form of housing set-asides, whereby landlords accused of discriminating against a complainant based on their lawful source of income agree to resolve the complaints by designating a certain number of rental units in the future for voucher holders. To date, the Commission has secured 127 such set-asides through pre-complaint intervention or conciliation. After a complaint is filed at the Commission, the parties may agree to settle their dispute or conciliate the claims. The complainant may withdraw their complaint, the Bureau may dismiss it, or after an investigation, the Bureau may issue a finding of probable cause or no probable cause. If the Bureau issues a finding of probable cause, the case is referred to the New York City Office of Administrative Trials and Hearings, where an administrative law judge holds a trial to make a recommendation on liability and remedies, which is eventually sent to the Commission's Office of the Chair for final adjudication. The Office of the Chair reviews the trial record and ALJ's recommendations de novo, then issues a decision and order including the Commission's final determination as to whether a violation of the city human rights law occurred, and if appropriate, issues an order for remedies. Remedies can include damages to the complainant, civil penalties of up to $250,000 per discriminatory act, and other forms of affirmative relief, such as a requirement to undergo training, revise policies consistent with our law, perform community service or other types of restorative remedies, or undergo monitoring to ensure that violations do not recur. In the last 5 years, the Bureau filed 853 claims of housing discrimination, alleging race, color, national origin, or lawful source of income discrimination. In fiscal year 2020, complaints filed with the Commission alleging housing discrimination based on race or color comprised approximately 5% of all housing discrimination cases. Complaints involving discrimination based on national origin also comprised 5%. In comparison, the leading bases for housing complaints were lawful source of income, constituting 29% of all housing complaints, disability constituting 25%, and immigration or citizenship status constituting 9%. In a recent decision and order issued by the Commission in November 2020, a landlord discriminated against a tenant based on her perceived immigration status as an undocumented immigrant during the course of eviction proceedings, then retaliated against the tenant for seeking assistance from the Bureau. In an effort to harass and intimidate the tenant, the landlord threatened to contact, and then did contact, federal immigration authorities to take action against the tenant. The Commission found the landlord liable for discrimination and retaliation, awarded complainant $28,000 in emotional distress damages, ordered the landlord to undergo training, and imposed a civil penalty of $12,000, which could be set aside in its entirety if the landlord elected to complete in good faith a restorative justice process. Notably, while the claim brought in that case was based on immigration status, it had the effect of pushing a single Black mother out of her home. In light of such cases, I encourage the committee to think broadly about intersectional identities and proxies that can be used for race, even when race discrimination is not directly alleged in a particular case. Housing policies that discriminate based on a tenant's use of a housing assistance voucher, immigration status, disability, credit history, or criminal history may have a disproportionate impact on Black and Latinx people. Housing reform efforts should account for these realities as we look for solutions to the deep-seated problems of racial disparities in secure and affordable housing. Thank you for inviting me to speak with you today, and I'm happy to answer any questions you may have.
Thank you so very much. All right, and I'll call upon our last speaker, and that's the New York City Civil Justice Coordinator, Jordan Dressler.
Somebody had to do it. Can you hear me okay?
Yeah, I can hear you now. Thank you.
Apologies to all. Good afternoon, and thank you to the members of the New York Advisory Committee, to the U.S. Commission on Civil Rights for having me to speak today. My name is Jordan Dressler, and I am New York City's Civil Justice Coordinator. In this capacity, I lead the city's Office of Civil Justice, a unit of New York City's Department of Social Services and Human Resources Administration. DSS HRA is the United States' largest social services agency, assisting more than 3 million New Yorkers annually through the administration of a range of public assistance programs. In administering these programs, DSS is at the forefront of New York City's efforts to combat poverty, reduce income inequality, and promote economic stability. And in a city where the median household income of a white household is almost double that of a Black household, and more than double that of an Hispanic household, where Black and Hispanic New Yorkers are overrepresented in high poverty neighborhoods, and where since the pandemic, loss of work has disparately affected New Yorkers of color compared to white New Yorkers, these efforts are critical to the city's work in advancing racial equity and ensuring that the city of New York continues to fight discrimination, confront segregation, and take action to advance opportunity for all. Providing civil legal services for New Yorkers in need, in particular legal services for tenants, is an important element in this ongoing work and is part of New York City's Prevention First strategy to address homelessness and promote housing and neighborhood stability for tenants. Services for tenants are critical in a city of renters like New York, where over 68% of households rent their home, compared to approximately 36% nationally, and where disproportionately those renters who are the most severely rent burdened are people of color. Since 2014 and the start of the administration of New York City Mayor Bill de Blasio, the city has dramatically increased its investments in legal services for tenants facing eviction, harassment by unscrupulous landlords, and other forms of displacement. In city fiscal year 2013, mayoral funding for tenant legal services totaled approximately $6 million, compared to $166 million in the city fiscal year 22, starting on July 1st of this year. These investments have enabled the city to expand initiatives that provide free legal assistance to tenants facing a range of housing-related legal issues and launch new initiatives to protect tenants facing the threat of eviction. A centerpiece of this work is our implementation of New York City's groundbreaking right to counsel law. With enactment of this law in 2017, the City of New York became the first city in the United States to ensure that all tenants facing eviction in housing court or in public housing administrative termination of tenancy proceedings have access to free legal services. The city's right to counsel law tasks OCJ with providing access to free legal representation to tenants who are respondents in eviction proceedings, whose household income is at or below 200% of the federal poverty line, and brief legal assistance for those tenant households earning more. Prior to the COVID-19 pandemic, OCJ undertook a multi-year implementation plan to increase the availability of legal representation for tenants in eviction proceedings in New York City Housing Court, identifying high-need neighborhoods across New York City by zip code based on factors including the number of entries into the homeless shelter system, the prevalence of rent-regulated housing, the volume of eviction proceedings and executed evictions, input from community-based tenant advocates, as well as other factors of need. The launch of right to counsel legal services in the city's housing courts involved close collaboration between OCJ, over a dozen city-contracted nonprofit legal services provider organizations, and court administrators and judges to develop robust and reliable processes for tenants in target zip codes who were facing eviction cases to be connected with available free legal counsel. OCJ worked with system stakeholders to create intake processes to identify low-income tenants in these zip codes and connect them with legal services providers to receive full legal representation in their eviction cases. To accomplish this, the courts routed newly calendared cases drawn from the target zip codes to their own designated courtroom, where right to counsel legal services providers established intake operations close by these designated courtrooms, allowing eligible tenants to access services in an efficient and effective manner. These efforts to expand access to legal services for New York City tenants have shown positive results. At the end of calendar year 2019, 38% of tenants citywide, nearly 1 in 4, who appeared in eviction proceedings in New York City Housing Court were represented by counsel. In 2013, the rate was only 1%. In the high-need neighborhoods targeted through right to counsel for implementation of in-court access to free legal representation for all low-income tenants, 67% of tenants who appeared in court were represented by counsel as of the end of 2019. These gains in closing the justice gap for tenants have been mirrored in an unprecedented reduction in residential evictions in New York City by city marshals since 2013, which declined over 40%, from approximately 29,000 in 2013 to 17,000 in 2019. Furthermore, when lawyers have represented tenants in court, they have been successful in preserving the homes of thousands. Between 2017 and 2019, in housing court eviction cases resolved by OCJ's legal services providers, approximately 84% of households represented in court by lawyers were able to remain in their homes, not only saving thousands of tenancies, but also promoting the preservation of affordable housing and neighborhood stability. The processes we put in place to expand and enhance legal services for tenants have proven to be critical as the city faced the devastating impacts of the COVID-19 emergency. Since the start of the crisis, OCJ and its nonprofit legal services providers have been working to ensure that all New York City tenants who are facing eviction in court have effective access to free legal assistance by eliminating zip code-based screening to make services accessible to tenants citywide, by standing up a housing legal hotline to provide access to phone-based intake, advice, and other assistance, and by establishing protocols with the housing court to virtually connect unrepresented tenants facing eviction in court with assigned legal providers to provide free legal representation in their eviction proceedings. As critical as providing legal services to tenants has been to reducing evictions and housing stability for New Yorkers in need, it has also been important in promoting fairness and equity in our legal system. As recently detailed in Special Advisor Jay Johnson's eye-opening report about racial bias in the overall New York State court system, the New York City Housing Court, one of the highest volume courts in New York City and one in which the overwhelming majority of tenant respondents are people of color, has suffered from a lack of resources, physical facilities that are ill-suited to the dignified and efficient administration of justice, and a culture described as demeaning and dehumanizing in the way it treats its litigants, including, and I quote, delays in case processing that cause cases to be adjourned out of necessity, meaning that unrepresented litigants must take another day off from work or arrange for childcare. The right to counsel for tenants is not a panacea, but the legal services staff who every day work to implement the right to counsel law for tenants in New York City help to address these pernicious issues and are transforming the city's housing court into a fairer and more equitable place for those in need. They work to ensure that the rights of tenants, disproportionately Black and brown, low-income tenants, are not violated. They connect tenants with rental assistance and other public assistance programs that help to ensure their economic stability. They make innovative legal arguments that pro se tenants would be hard-pressed to make themselves and that help shape the jurisprudence of the housing legal system. They often appear in their clients' stead, allowing their clients to avoid missing work or the challenges of childcare. In addition, tenant legal services attorneys, by their very presence in the courts, shine a light on discriminatory or biased behavior that might otherwise go undetected or unchallenged. A recent incident illustrates how right to counsel legal services are critical in highlighting and addressing racial bias in the housing legal system. Last month, in Staten Island, a landlord's law firm served dozens of eviction petitions on tenants, including a tenant notice that read, and I have to quote here, Chinese Wuhan virus emergency, where it should have said coronavirus emergency. Including this odious language in a legal notice was a perversion of a court rule enacted last fall, for which we and our legal provider partners advocated, that requires that new eviction petitions sent to tenants include a notice stating that the tenant may be able to raise pandemic-specific defenses in court and should contact OCJ's free legal services program for assistance. Tenants served with these notices were indeed contacted by one of our legal services provider partners, and counsel urgently brought the hateful notices to the attention of the court, where 2 days later the cases were summarily dismissed by the administrative judge for New York City Civil Court. It is difficult to imagine that an incident like this would be elevated to the highest levels of court administration for such hateful conduct to be swiftly and appropriately penalized without the action of tenants' counsel. With that, I want to thank you again for the opportunity to speak with you today, and I'd be happy to take your questions.
you so much. And thank you to all of our panelists for your really, really informative and impressive presentations today. We're going to start the committee's Q&A, and I'm going to call according to roll call. We have 9 members of the 14 members who were able to reschedule and attend with us today. So Athena, Utah, do you have any questions? A question each?
Yes. Thank you, panelists. This was really helpful. I have a ton of questions, but let me start with the one, and I guess it's really addressed to Chair Malalis and Mr. Johnathan Smith. And it's a quick question, and that is, I'm assuming that your cases and settlements are public, and how might we access those cases so that we might take a look at them? So that's one part of the question. The other is more broadly directed to the panel, and that is, how might you evaluate of enforcement in the eviction area? So it seems to me, and I may be wrong, and I'd love anybody to speak on this, that enforcement is largely reliant on private action, right? So it's private enforcement. It's folks filing complaints or instituting cases and that sort of thing. And then there is some public enforcement, but I'm not quite sure what that looks like. And so I would love for you to give me some sense of what the balance is here.
Okay, so the way we'll organize the responses, I'm going to call on the 2 commissioners first, since the questions were posed to you in terms of the narrow issue, and then I'll open it up to the panel. I would ask you to raise your hand on the participant list so that I can call on you based on you raising your hand. If you don't wish to answer, by all means, don't raise your hand. But let me start with the 2 commissioners. Commissioner Smith, do you wish to answer the question that was posed?
Sure, thank you for the question. So yes, they are all matters of public record. All final orders that are issued by the commissioner those are available on our website. We do also settlements, or the vast majority of settlements are also resolved through kind of public orders as well. Some of those are available publicly, others are available through FOIL or through the Freedom of Information law. I do think if the committee, if there is specific information that the committee has about our orders or settlements, if you all want to send those to us, we can see if we can also provide additional information to you all as well. And then the last thing I would just say to your second question, so yes, a lot, at least for the state division, a lot of our complaints are complaint driven, right? So people are coming and filing complaints. We do have the authority, like I believe the City Commission does, to institute our own affirmative complaints. And so, for example, I think Jordan mentioned the issue from Staten Island. I know our agency, as well as a sister agency, also opened an affirmative complaint into those allegations as well. And so, when we do become aware of kind of patterns or practices of discrimination, and we can affirmatively investigate those as well. We usually learn about those either through the media, through advocacy organizations, and the like, things like that.
Okay, there was also a question posed for Commissioner Malalis. I don't see your hand raised, but do you want to answer the question?
Yes, sure.
Yeah.
Sorry about that.
Thank you.
So similar to our colleagues in the State Division, much of our information is also available on our website. So by statute, we have to provide an annual report that we also post on our website, and it breaks down the different areas of jurisdiction as well as the resolutions for a lot of the cases that are filed. If you look on our website, you can also find information on the different decisions and orders. All of those are listed on our website, as well as many of the settlements that are of interest. And anything that you're not finding on the website, or if there's other information, certainly if this committee would like to see some information, we would be happy to provide that. Members of the public are able to FOIL that information publicly, just as with our State Division counterpart. And in answer to the second question, so I came into my role in February of 2015. Prior to that, in the context of housing, many, or I would say most of the cases in the housing context were largely complaint driven. While we still do get many complaint driven matters, as I mentioned in my testimony, in 2016, we revamped our testing program. And that was in part to give us, much more robust tools in this specific area in housing. So we have greatly increased commission initiated efforts in this space. And, that is coming not just from testing, but that's also coming from, tips from the media, tips from other elected officials, tips from the public. And if you take a look again at any of our annual reports, you'll see that it breaks down what the testing categories are, what the inquiries are, and also what I would point out is we have greatly increased in the housing context pre-complaint intervention. So if you're really looking at a full picture of what the Commission's enforcement is in this area, it's important that you're looking not just at complaints filed, but also at the pre-complaint intervention work. And we started doing that much more aggressively in the last 5 years, with the recognition that, people need housing. We got to get people into housing rather than litigating the case. So you'll see a lot of the work has shifted from complaints into pre-complaint intervention, especially in this area, with lawful source of income discrimination being probably the lion's share of that work.
Okay, thank you. Seeing no other hands raised, I'm going to go to the next committee member, Jamil Dakwa. Do you have a question, Jamil?
Yes, thank you, Chair. Thank you for the panelists for your very informative presentations. I have a question with the two parts to Commissioner Smith and Chairwoman Malalis. To what extent there is cooperation between the New York State and the New York City commissions on these issues? If you can give us a sense of how does that work, particularly I'm really interested to know about around the different procedures that you are employing, such as the testers program or the testing program that seems to be making results on a pre-complaint intervention. To what extent there's collaboration, particularly when the state is getting half of things, nearly 50%, as Commissioner Smith said, are coming from New York City. So how is that being done? And then the second part is what recommendations that you may have for us to make in the report to the state and to the city of New York, to the city of Buffalo, Albany, but to the state of New York, that you would think would be addressing some of the issues that you've heard from Sandra Park and particularly about the issue of gender and race, intersectionality on the eviction policies and some of the race and gender discriminations impacting particularly women of color. Thank you very much.
Okay, Jamil, I just want to clarify, are both these questions, the two-part questions, just for the commissioners, or is it the second part opened up for others as well?
They're open up. They're open to other panelists. Good.
Okay. All right. So let's start with the commissioners then. Commissioner Smith.
Sure.
And again, I've asked the panelists to raise their hands, but since he directed it to you, let me call upon you. Thank you, Commissioner Smith.
Great. Thanks, Jamil, for the question. Good to see you. I think that there is collaboration and cooperation between the State Division of Human Rights and the New York City Commission. I think that that's a place where, in my view, there's probably more that we could do to strengthen those partnerships. And so, just as a technical matter, and I'm sure Carmelyn will correct me, if I get any of this wrong, but when someone files a complaint, they have to choose a form, right? So they could choose the state, they could choose the city, they could choose HUD or a federal agency, but you have to kind of pick one place. And obviously, because it wouldn't make a lot of sense, from a legal perspective or from an operational perspective, for kind of different agencies to investigate the same complaint at the same time. And so I think typically people pick one forum, and that's what happens. I think where there is, I think, where there has been collaboration and where there, I think, could be even more collaboration going forward is around, I think, either issues around outreach, training, engagement, making sure that individuals understand the differences between our laws. So, for example, for a long time, the city had lawful source of income protection. The state did not. Now we do have that protection, but the protections are not always identical. And so, making sure that tenants or any New Yorker understands kind of what the law covers, and they may as in any case, I don't want to use the term forum shopping, but obviously people should pick the forum that they think is best for the claim that they have. And so making sure that New Yorkers understand that, which I think oftentimes can be confusing because there are many there are different agencies. I would also say too that there's the New York City Commission, which is a great agency, as Carmelyn mentioned, but there are other local human rights agencies across the state. There's about around 30 of them across the state, and one thing that we've tried to do over the last year or so is increase cooperation among all of those entities, right? So that way we're working together. Where we can, we're speaking in one voice, and where we can't speak in one voice, we are at least communicating with each other so we understand what our different sources of jurisdiction are, how we can work together, where our legal authorities are. And so, I think that it remains a work in progress, but I am happy that we have, I think over the last several months across the state, worked really hard to make sure we have more regular and more robust lines of communication with all of our kind of partners across the state to make sure that we are working together effectively in that work. And then just to answer your last question quickly, I do think where, I'll only speak for the state, but where, the state legislature over the last few years has done a lot to increase the range of the scope of the human rights law. I mentioned lawful source of income, but there's other changes that have happened as well in other areas, both housing related and not, that I think have allowed, both the State Division of Human Rights, but also has given additional resources for New Yorkers who want to file private right of actions in state court around discrimination. And so I do believe continuing that trend and making sure that we are identifying all the forms of discrimination, how they manifest, and making sure that the state law is keeping up to pace with that, I think is something that we've made progress on in recent years, but I'm sure that there's more work we can do along those lines.
Thank you. Commissioner Malalis?
Sure. I'm not going to, I won't add too much to what Johnathan already mentioned with regards to the communication and the cooperation between our agencies. He and I have enjoyed a very good relationship. I've also enjoyed a good relationship with his predecessor. I think we've done a very good job of trying to coordinate on different issues so that, frankly, information is not confusing to the public. So where there are changes to either of our laws, and we think that it makes sense for us to coordinate on notices or information that we're providing to the public, and the panoply of different constituents, whether it's know your rights related or know your obligations related. I think we've done a pretty good job of coordinating our efforts. We certainly did it a few years ago when there were great changes to enhance sexual harassment protections both at the state and city level. Again, we wanted to make sure that there was one place where people could understand what their obligations or what their rights were. And I think we did it again recently, as Johnathan mentioned, the state law was just amended to include lawful source of income protections. And when a notice was being released by his agency, we wanted to make sure that differences in our law and his law, the state law, were included so that people understood if they had different remedies under city law versus state law. To your other point and to your other questions, I would say similarly to the State Division, we've tried very hard to keep up with what I often think about as, kind of the proxy issues where, again, race or national origin may not be identified necessarily as the driving factor, but because of the disparate impacts that we see on Black and Latinx communities, for example, we know that they are proxy issues. Some of the issues that were mentioned by Sandra, for instance, include, people who are victims or survivors of violence in their homes and wanting to make sure that they are not more vulnerable for eviction. So New York City has had protections against discriminating against somebody in the context of housing if they are the survivor, if they are victims of survivors of domestic violence, stalking, or other similar types of offenses for precisely that reason. I mentioned some of the other proxy issues we deal with. Sexual harassment, which is another issue that Sandra mentioned, that is absolutely something that we look at in the context of housing. And, again, if people want to take a look at some of the decisions and orders that we have listed on our website, there was a recent housing case involving a transgender woman of color where sexual harassment was one of the claims mentioned and one of the issues raised before the agency.
Thank you very much. We will go to our next committee member, Don Durham. Do you have a question?
Sure. For both commissioners, starting Commissioner Smith, because I wrote your numbers down, you mentioned numbers 740 cases, 340, then 180, and then you said 43. A pretty definitive number, where there have been settlements or adjudications. I'm just curious. I know you said that a lot of those cases are still under investigation and are not fairly subject to discussion, but how many cases did you dismiss or find no probable cause, or did the person go to a hearing, the landlord go to a hearing and prevail? Because it sounds awfully one-sided here. I don't think any of you means to say that the tenant is always right and the landlord is always wrong, but it doesn't seem like anybody is standing up for the landlord here.
So the question is directed to the two commissioners. Commissioner Smith, do you wish to answer the question?
Sure. Thank you for the question. So, I don't have, unfortunately, the numbers that I provided are the numbers I have for today. But as I said, to a prior question, if there's other information that you want, that the committee would find useful, including information like you mentioned around no probable cause rates, we are happy to provide that. As I believe Carmelyn mentioned as well, that information is also provided, at least in an aggregate way, in our annual report, and kind of other documentation that the State Division has made available to the public. So certainly from the State Division's perspective, I don't think that's an issue of kind of hiding the ball. I will say just, just to say what you would see if you looked at our annual reports, like, yes, I mean, a good number of our cases are either found to be no probable cause or are, proceed to a public hearing, and then the determination is that the complaint should be dismissed, that there was no kind of evidence of discrimination. And so, yes, so certainly, and one thing I would say as well, one thing that I think is also maybe slightly different from the process of the City Commission is that the entire kind of case lives in the State Division of Human Rights. So we investigate the complaint. We have administrative law judges within the division who then hear those cases. We also have lawyers who represent cases where they don't have private counsel. And then all of those matters that don't settle come before the commissioner for final adjudication. And so because we are, we play a role both as investigators and then also adjudicators, I think it's really important, and I know my colleagues in the division feel it's really important that we don't, kind of weigh our hand in favor of either side, right? It's really important to our process that it be fair and that it be neutral, that we kind of evaluate the facts. However, the reason why I think, kind of highlight the numbers where, there have been settlements or where have been favorable dispositions for tenants or complainants is because, I believe it just shows the types of complaints we're getting and where we have found kind of credible allegations of discrimination. And so certainly there are lots of cases in this context and others where we don't find that to be, where we don't find credible allegations, but certainly there are, I think a significant number of cases where either through settlement or final resolution, we do see issues of concern of racial discrimination in the housing and specifically eviction context.
Thank you. Commissioner Malalis, do you wish to answer the question? I see your hands up.
Sure, absolutely. And I would be very happy to respond to the thrust of what I believe Mr. Durham's question is. If you look at the broad number or the larger number of inquiries that flow into our agency. So for example, if I just look at fiscal year 2020, and I look at the total number of housing related inquiries that came into our agency, and again, this information is available on our annual report. There was something around, I think, 1,500 or around that number, 1,500 related housing related inquiries. From that larger number of inquiries, if you look at the actual of complaints actually filed in the context, and so if I look at the context of just race, color, national origin, source of income related cases, there were something like 60 plus maybe cases actually filed in that space. The delta, the great delta between these numbers is one, certainly other categories of protection besides race, color, national origin, and source of income, but also because we do, one of the reasons we did prioritize doing pre-complaint intervention work was that in some instances, rather than filing a complaint and going through a full litigation, it made much more sense to engage in a process by which we educate landlords or housing providers about what the law was or what the law is and what the obligations are. In other contexts, there's investigations and there is either no probable cause finding, or in other situations, there's also administrative closures if we find that what was raised is likely to not result in a probable cause determination. And it's really not in the interest of the public to go ahead with that sort of case through, after a complaint has actually been filed. So there's a lot of education and a lot of training that comes into the work that we do, which is why we have a community relations bureau that takes that more kind of education and outreach approach. A lot of the work that's done at the agency is actually outside of the litigation context, outside of the complaint process, because we do want to make sure that if there are conflicts that arise between housing providers or any other entities that have obligations under our law and individuals, where education and affirmative measures can be taken to alleviate the issue, that is what happens, rather than just immediately going to a litigation posture.
Okay, thank you very much. Let me go on to the next committee member, Tiffany Graham. Do you have a question?
Yes, thank you as well to the committee. This was incredibly informative. My question is for Deborah Thrope. One of the things that you mentioned as a recommendation was to have, I believe it was the federal government track illegal evictions. And you said that when your organization did that, I believe that you did a survey of on-the-ground advocates, and they were able to collectively provide information about what they had been told from people who had experienced this. But that's a survey from your organization. How would you recommend replicating that kind of effort, either on a state level or on a national level?
Okay, Ms. Thrope.
Okay, thanks so much. Sorry, couldn't unmute myself. Thank you so much for that question. And it's a really important one. Some of you may be familiar with Matt Guzman's book, Evicted. I believe there were some speakers in another panel from Peter Hepburn from the Eviction Lab. And, they're really the first major researchers to quantify evictions. And the way the work started was Matt Desmond, because the eviction data in general is so hard to get a hold of, Matt Desmond sat in the courtroom and actually tallied the evictions himself. Right now, we figured out different ways to, in certain courts, certainly not across the country, to capture this data, but it is grossly underrepresenting the number of evictions because of this problem of illegal evictions that are outside the jurisdiction of the court. And when I say that, I mean these evictions related to landlord harassment, or you know, the landlord says, listen, I'm going to make a deal with you, right? If you, to the tenant, like if you leave within 10 days, I'm not going to file. And so a lot of tenants don't know their legal rights. They don't understand their legal rights. And so they just leave. So it's a really great question about how to capture the number of illegal evictions, again, outside of the jurisdiction of the court. And, you know, our survey scratched the surface, and you know, we did hear a lot about an increase in these illegal evictions during COVID, in part because of some of the protections that were in place at all levels of government. But I think, you know, one way to do this is to you know, to do these types of surveys and to, you know, reach out to tenants. But it's very time consuming and it's very challenging. And it's a really great question. I think with the resources, you know, you know, starting with the local government, we could be able to scratch the surface. The other thing I will say is, you know, the eviction data, you know, there's glaring holes in eviction data across the country, but there are steps that we can take for to sort of chip away at that. Eviction Lab has done a really great job. Another example is that we don't even track evictions, legal or non-legal, among our federally assisted housing programs. So HUD does not collect data for you know, regarding evictions for their own tenants. So that would be one place, for, you know, for example, we could start to really gather some meaningful data around evictions, but people are often surprised to find that out, for example. So maybe starting with a smaller, you know, tenant sample would be the way to go. But thank you for the question.
Thank you so much. So I'll call on our next committee member, Bob Klump. Do you have a question? Bob, I think you have to unmute yourself. Do you have a question?
Yes, I do. Can you hear me?
I can, thanks.
Okay. Let me start the video here too. Several of you emphasized, I think it's fair to say, the fact that the eviction rate is the highest among Black women. And in fact, I was looking in preparing for this session at some of the statistics on that. And for instance, an article in Sage Publications published recently noted that there was 24.2% greater rate of evictions against Black women than Black men. And I'd like to ask whoever would choose to respond, who would want to respond, what would be the reason for that? I mean, if the discrimination is on the basis of color, then how does one account for the consistently higher rate of discrimination in terms of evictions against Black women as opposed to Black men? Is it because, as I might hypothesize, that the majority of children in single-family households, single-family minority households, are living with mothers rather than fathers?
So I will ask the panelists to raise their hand on the participant list so that I can call on you according to how you raise your hand. That question is for anybody who would like to answer it. Okay, Sandra Park, thank you. And if others, while you're listening, wish to respond, please raise your hand while Ms. Park is speaking. So Ms. Park?
Yeah, I think that's an important question. I would refer you to some of the research that's been done by scholars and academics on this. Matt Desmond has been discussed earlier, and one of his observations from his research is that the eviction crisis is a parallel to mass incarceration, and that Black men are locked up at disproportionate rates. And as a result, Black women are often left as heads of households, and they are locked out because of the rates of eviction that they experience. So I very much think of this as an intersectional race and gender issue. And it's important to think about the fact that it is Black women, both by virtue of their race and their gender, that are disproportionately affected and face eviction filings. And so for a lot of the data that's out there, and I think Eviction Lab has done this as well, really trying to analyze this eviction data along race and gender axes, and recognizing that that it is a racial justice issue as well as a gender justice issue, and both need to be understood.
Thank you. Do any of the other panelists wish to answer the questions? Seeing no other hands raised, I will go to our next committee member, Rafael Manguel. Do you wish to ask a question?
I do, thank you. So pretty much all of the panelists have cited the delta between the eviction rates of, say, Blacks and Latinos on the one hand and whites on the other. My question was going to be, to what degree do those eviction disparities shrink once you control for example, whether and how much rent is owed? But a lot of you have mentioned Matthew Desmond over the course of the hearing, and so I looked him up and came across a 2016 study in the Harvard Civil Rights and Civil Liberties Law Review on eviction data out of Milwaukee. And one of the things that he writes in this study is that no study to date, however, has examined whether groups protected under the Fair Housing Act, and racial minorities in particular, are more likely to experience eviction controlling for eviction warranting behavior like non-payment of rent. And then the study presents data that, again, was unable to find any disparities that could possibly be attributed to racial discrimination. And so my question to the panel, particularly to Sandra, is has the literature changed in any way since this study? Do we have any information on whether and to what degree racial disparities shrink once you control for relevant factors like eviction warranting behavior?
Okay, so any of the panelists are welcome to answer that. He certainly called you out, Ms. Park, and others can answer as well. Ms. Park, do you wish to answer the question?
Sure. I think I would certainly refer you to the Eviction Lab's testimony, as well as I know Peter Hepburn spoke with you all. There has been more recent research, that looks at, for example, amounts of back rent that are due that have caused eviction filings, some of which have documented that very small amounts of back rent due have triggered eviction filings. There's also been research done on the nature of serial filings, so where landlords are essentially using filing of evictions to try to force payment of rent, and so filing multiple evictions against households, and that in fact there's a racial disparity that has been found there, where it is actually more likely for a white household to ultimately get a judgment of eviction if you account for serial filings. And that refers to one of the statistics I spoke with earlier, where what we have found is that Black women-headed households are much more likely to face eviction filings that are later dismissed. And so that connects to my concern around eviction records, and how those records are then used against applicants categorically to exclude them from future housing opportunities. But I think those are some of the studies I would refer to that are newer. I agree that they're going back to what Deborah referred to, this area is still relatively nascent in terms of really understanding all the different factors that lead to both eviction filings, and what we would judge and how we think about outcomes and racial disparities. But what we've seen thus far certainly shows that those racial disparities exist in terms of the filing of evictions. I would point to actually one other study done by Professor Tim Thomas, who has been doing some of this research around the country, and he has tried to control for some of these factors, including in the Seattle area.
Thank you. I see Commissioner Smith's hand is raised. Commissioner Smith.
Great, thank you. Yeah, I certainly can't speak to any of the kind of social science data that Sandra mentioned, and so I won't comment about that. But I will just say, in the context of the types of complaints that we see in the Division of Human Rights, where the whole premise, of in order for a claim to ultimately succeed, there has to be an underlying, obviously successful claim of discrimination. Of which simply non-payment of rent obviously would not qualify without more. But I do think even from just the anecdotal data that we have, we do see some cases where racial discrimination seems to be playing a role separate from non-payment. So again, I would certainly not disagree that probably more research could be done, and but certainly in just the small sample size that we have, I think we have reason to believe that is a problem worthy of addressing.
Thank you so much. So let me go to the next committee member, Craig Trainer. Do you have a question for the panel?
No question, Brianne. Thank you so much.
Okay. I have a question for Jordan Dressler. You had mentioned Jay Johnson's report, which I've had an opportunity to read, and I've also had an opportunity to speak to some of the housing court judges. I'm a retired family court judge, and I'm wondering what, if any, effort has been made to have court administration and the housing court judges note the demographics of the landlords and the tenants that come to court. We're hearing there's a great deal of problems with the data and being able to use reliable data, that there's essentially an imputation of race based on various factors. So my question is really, what could the court do to help us collect the data to better be able to do analysis? And that's for Mr. Dressler.
Thank you. Thank you for the question. I wouldn't presume to speak for the court system, the state court system. We are their partners, but we are not them. I will address the issue of, to what extent we're collecting race and ethnicity information within our own programs. And, the simple fact is that as we sort of launched these programs and built the plane as we flew it, to abuse a metaphor, we really stuck with a policy with our legal services providers of only collecting or asking them to collect, rather, that information which was critical to the administration of the program, and making sure that we were not setting undue informational burdens on them or their collection with their clients. Though, as we are now sort of overseeing a more maturing and more robust program, I think we are seeing that we cannot fix what we cannot see. And so we are working with providers to figure out what the right protocols are for an easy way of collecting that information in a way that's going to be meaningful and helpful to us in the administration of the program, but also making sure that we are getting the right kinds of information that might show disparities even in the administration of our program itself. So that may serve to either be a proxy for all the cases in court, particularly as we continue to implement, or it may be just helpful as a representative sample of what is happening in housing court writ large.
Thank you very much. So we have another 5 minutes. Let me just circle back to the committee members. All who wish to ask questions that's on the call have been able to do so. Are there any committee members that would like to ask an additional question? And it will need to be a quick one. I see a couple of quick hands go up because we've literally only got 5 minutes, and then we'll only have 15 minutes for public comment. And I know we have one public comment speaker. So Tiffany Graham, you get the next question.
Yes, thank you. My question is for Commissioner Malalis. I'm really intrigued by your conversation about proxy-based discrimination, and I just wanted to clarify if you guys had done any data mining in order to determine how frequently race in particular intersects with lawful source of income discrimination, how frequently race intersects with disability-based discrimination, how frequently it intersects with immigration status discrimination. I accept your claim that these are serving as proxies, but I'm just wondering if you guys have done the research to figure out how often the intersection occurs.
Hi, so thank you for the question. We ourselves have not done research on this, but some of the research that we rely on for that is included in my written testimony. For example, one of the sources that we cite shows that Hispanic people represent 45% and Black people represent 36% of all housing choice voucher participants in New York City. There's other data that we include that shows that while Black families represent about 22% of all households in New York City, they make up 27% of households headed by a person with a disability. And certainly, though I don't have the statistics on hand for this, I can tell you anecdotally that, of course, in the complaints filed with the agency, there are oftentimes multiple claims that are asserted in the complaint. To have race or color come along with disability is not uncommon, as it is also not uncommon that we see lawful source of income alleged along with race or color, national origin, or immigration status.
Okay, thank you. I think we have time for one more quick one. Raphael?
Thank you. Yeah, I was just struck by what Mr. Dressler said regarding the collection of demographic data and the outcomes of some of these things. I wanted to just propose this question to both Commissioner Smith and Malalis, which is, are there any racial disparities in the outcomes of the complaints or investigations undertaken by the commissions that you guys oversee? In other words, say, are Black tenants more or less likely than white tenants or landlords to prevail in their claims before your commissions or divisions?
Okay, so Commissioner Smith, do you wish to answer the question? And also Commissioner Malalis.
Sure. I mean, I just want to make sure I understand the question. So is the question whether we are aware of, or I guess for the state division, I'm aware of racial disparities in the outcomes, of housing related matters? Is that the question?
The matters before your division. Are you aware of any racial disparities in terms of the outcomes of those complaints or any investigations undertaken by the division?
I mean, I am not. I would say that, as Carmelyn, I think, mentioned, or at least is assumed in, I think, her prior question, I mean, obviously there are, the baseline's not the same necessarily for the types of complaints that are being received across a number of different protected classes, but certainly I'm not aware of any racial disparity in outcomes, or I should say any disparity in outcomes or any type of protected basis. And yeah.
And Commissioner Malalis?
Sure. So similarly, I'm not aware of racial disparities in that context either. And if the question is about are people from certain types of racial demographics more likely to prevail after filing complaints or claims at the agency, one, no such claim has been made to the agency. That issue has not been raised for us. And two, it's not really information that is tracked to look at the demographic racial identities of the complainants who file matters with us to compare that against the demographic racial identities of, for instance, individual respondents that come before us in those cases. And I will also add, I'm not aware of any law enforcement agency that tracks that type of information.
Okay, thank you so much. At this time, we're at 5:45, so we have used the time that we have. I want to thank all the panelists so much for participating and again, rescheduling on such short notice. This has been incredibly helpful to the advisory committee. I thank my colleagues for asking the questions and listening. At this time, we're going to go into public comment. The panelists are welcome to stay on and listen to public comment. I know we have at least one speaker, so if you'd like to leave this session, you're welcome to do so, okay? At this time, we're now going to begin the public comment. It's an opportunity for the public to offer comments to the committee about this topic. I ask that the public that chooses to speak to us to please keep your comments limited to 2 to 4 minutes. As a reminder, all remarks are recorded for the public record, and as the chair, I reserve the right to cut short any statements that defame, degrade, or do not pertain to the issue at hand. I will now invite members of the public to share brief statements with the committee, and I'm going to start by inviting the comments from those who have notified Mallory Trachtenberg of their intent to speak today. I'll follow that with those who raise their hand by using the raise hand by selecting your name in the WebEx or selecting *3 if you're joining by telephone. And then lastly, I'll call on those who email Mallory at mtrachtenberg@usccr.gov asking to speak. So our first speaker this evening will be Jung Choi, and I want to thank you so much for being willing to speak to us today. So you can unmute yourself, and we have your slides up.
Great. Thank you so much for inviting me and giving me an opportunity to speak today. Today, I will be talking about small rental units that are owned by mom-and-pop landlords. Next slide, please. So small rental units, namely 1 to 4 unit properties, account for about half of the rental properties in the U.S. There are currently about 23 million 1 to 4 units in the country. Most of these properties are owned by individual investors. Individual investors own about 75% of small rental units. Next slide, please. Small rental units, especially 2 to 4 units, are relatively more affordable. The median monthly gross rent of this property is about $100 to $2,000 lower than other rental properties. These units are also more likely to be owned by landlords of color. Next slide, please. So during the pandemic, renters in the small rental units were more likely to be behind on their rental payments. About 87 to 89% of tenants living in these properties paid their rent on time, which is about 5 to 7 percentage points lower than those living in large multifamily properties. This has affected the financial stability of mom-and-pop landlords who own these properties. Over 40% of mom-and-pop landlords said that they faced trouble making their mortgage payments since the outbreak of the pandemic. This number was higher for landlords of color who are more likely to have a mortgage, have a lower average income, and also are more likely to own only one property. So diversifying risk is more difficult for these landlords. About 30% of landlords also said that they face increased pressure to sell their properties due to the pandemic. This could affect the supply of affordable housing in the long run. Next slide, please. Our most recent survey also finds that many landlords and tenants in small rental units are still not aware of federal emergency rental assistance. In our May 2021 survey conducted about a month ago, we find that 56% of tenants and 40% of landlords in small rental units said that they were unaware of the federal emergency rental assistance. The application rate was even lower. 10.5% of tenants and 5.7% of landlords said that they applied for federal emergency rental assistance, and less than a half has been currently approved. The uncertainty of receiving rental assistance, unclear eligibility criteria, and complicated application processes were the major reasons they cited for not applying. Next slide, please. To increase housing stability in this market, as well as preserve affordable housing, we need to build better systems and infrastructures. One of our policy recommendations is expanding housing choice vouchers. Our survey also finds that lower income renters with vouchers own less back rent than those without a voucher. Mom and pop landlords who accepted vouchers had mostly positive experience. We also need to improve the efficiency of housing choice vouchers. Mom and pop landlords who do not accept vouchers that they did so because of the complex rules surrounding the program, difficulty of dealing with the ongoing property inspections, and long time approval to accept tenants with the vouchers. Additionally, we need to use this opportunity to build better infrastructure to allocate funding efficiently and effectively during the emergency. Currently, there is a lot of confusion about federal rental assistance, and the awareness level is very low. We need to quickly reach out to more people before the eviction moratoria expires, and also need to improve these programs. This can also be a long-term asset since the crisis, unfortunately, is likely to reoccur in the future. With this, I will conclude my comments. Thank you very much.
Ms. Choi, thank you so much for joining us today. Let me just inquire to see if there's any other members of the public who would like to share public comment with us. If so, please raise your hand by hovering your mouse near your name in the participant list. Likewise, if you're on the telephone, you can press *3 on the telephone keypad to indicate that you'd like to speak. I don't see anyone else at this time, but if anyone else would like to speak, you may still raise your hand. Let me just check with you, Mallory.
I have not received any emails during this that somebody wishes to speak.
Okay. So, Ms. Chung, we are going to stay live until 6 o'clock. I want to be able to go back and provide you an opportunity to speak longer to us if you would like to. I know you were given a limited time to speak, but we are going to use the entire time, which is 8 more minutes. Is there anything else that you would like to talk to us about in regards to these issues?
Hello, can you hear me?
I can hear you.
Okay, so I'm back to speaker.
Would you like to say anything else to us?
I don't think I have anything that pops out in my mind at the moment. Oh,
Okay.
and just one more thing. One of the things that we also found was that the landlords are also becoming very cautious of accepting new tenants. So they are saying that they're imposing stricter credit screening process. And we think that this is also affecting lower income people who are trying to find affordable rent during the crisis. So really helping the landlords kind of like financially weather this crisis is also, we think it's gonna help the tenants who are also struggling to pay their rent on time and find affordable place to live.
Thank you so much. I just want to say to my committee members, when we have people call in or present during public comment, we can ask only clarifying questions. It's not like there's speakers on a panel. If there's any committee member that would like to ask strictly a clarifying question of Ms. Choi with respect to anything she has said and presented on her slides, you're welcome to do so. Otherwise, we'll wait to see if there's any other speakers. Okay, I don't see anybody's hand raised. So we do have 6 more minutes. Let me just open up to my colleagues, as we did during our last public comment, to hear if any of you would like to share your thoughts on what we've heard today. We've heard from 5 panelists on the panel, as well as from Ms. Choi today at public comment. If you would like to share your thoughts on what we've heard today, please just raise your hand in the participant list. Tiffany, I see your hand is raised.
Thank you, Brianne.
Yes.
I will say that after this briefing and after the last briefing, it really does strike me again about the importance of data and the importance of not having as much data as we would like. And you know, I recognize and appreciate the professional conclusions that sophisticated statisticians draw based on what data they do have, but I also recognize that it's a developing problem, that we don't have more data to hand in order to truly evaluate this question. And I guess what the committee has to think about, and what we have to think about in terms of legal standards in particular, is the intersection between the evidence we have and disproportionate impact standards, or the standard of disproportionate impact, and thinking about how to frame that in our conversations as we think about what we want to say to the commission when we put together our report. It's troubling to me, and I just hope that we can continue having a conversation about how to sort through the data in order to reach a defensible conclusion one way or the other.
Thank you. Excellent comment. Let me hear if any of our colleagues wish to weigh in on that or share any other thoughts from today's panel presentation, public comments, or even the last briefing. Jamil?
Thank you. I agree with Tiffany. This is also probably one of the issues that we need to address in our study, in the report, and figure out a way that we could encourage more data collection in a way that would be helpful. But my main point that I want to make is that I think what we heard today is that while there are a lot of good prevention and enforcement to prevent discrimination, particularly racial discrimination, even if there's not enough data, I think what we also heard is once again, the need to address the structural issues that have made eviction a much higher risk, particularly for marginalized communities, particularly for people, whether it's based on race, gender, or class. And I think those are the things that I would want to hear more, hopefully from the next presenters, but we have to do more in terms of how do we really structure our recommendations, that it's not just about adding more resources for prevention, but rather an enforcement, but rather what is it that the state and local government need to do in order to really get us out of this cycle of people have to continue to live in this high cost of rent, and that leads to the higher risk of eviction, and how do we do that in a way that take into account historic injustices, and particularly the way that we don't all have the same access to resources and ability to, whether it's to defend ourselves. And I appreciated that testimony from about the access to counsel. Definitely that helps prevent the eviction problem, but I think that we need to really tackle it head on, and as our proposal suggests, it is really a structural problem that we need to address. Thank you.
Thank you, Jamil. I see Raphael's hand is raised. Raphael?
Yeah, I would just quickly caution the interpretation of that statistic on representation. I mean, the 84% number is compelling. I would have loved to have asked about it, but I had to sort of pick and choose between the questions I wanted to ask. But as far as I'm aware, again, the analyses here don't actually control for the representation in a way that we can isolate its impact. So we don't really know, based on the available data, what that percentage would look like in the absence of the representation. We have no idea to what degree the increase in representation has led to a change in eviction outcomes. So this is, I think, a running theme through a lot of this, and I just hope we all remain open to the possibility that we may not be in a position to find the kind of causation that I think we would need to recommend it basically infringing on the property rights of landlords.
Okay, and Athena, I see your hands up. You have the last comment as we close in at 6 p.m. Athena?
Sorry,
I think,
here talking to myself.
yes.
Okay. I think the last three comments were interesting. But I think it also depends on what we think our job is. So I think we have kind of a huge problem. From my perspective, even if this was simply income based, I think which goes to Jamil's problem, how might that be? Why is it that you've got 2 or 3 groups that have significantly less income in the world of the free,
Right.
the country of the free and the brave? So that would be one comment. 2, I think we're very clear from my perspective, Tiffany, that one of the things that we're going to have to recommend is more data collection. And so that to me is easy. The question is, I think that you're posing is, how might we frame that? And what kind of data collection do we need? What is it we're trying to get at? And so that recommendation is kind of clear and decided in my mind because that has been, I think, so obvious. I think I had one other point that I can now not remember. So it'll wait another day. It'll come back to me.
Okay. All right. Well, thank you so much. So I just really want to thank all the panelists. I want to thank the public speaker, Ms. Choi. I want to thank my colleagues who rearranged their schedule to be able to be here today. Thank anyone who's been listening from the public. We really appreciate everyone's time. And again, you can always submit written comments to Mallory Trachtenberg before July 25th. The briefing's going to continue this Friday from 12 to 5. We have a packed agenda with 2 multi-sector panels, a landlord forum, a renters forum, and public comment. So I look forward to seeing you all this Friday. You should sign on for 11:45 a.m. We'll get started sharp and we'll go from 12 to 5 p.m. Thank you so much. Have a good evening, day, and we'll see you on Friday. Bye-bye now.